Thank you and good morning. I don't have any war stories, but I guess we could save that for the Q&A if anybody's interested. What I'm going to talk about is what I think are the two greatest challenges and problems that create vulnerabilities in our legal immigration system, both for immigrant visas and these non-immigrant or temporary visas, that stress the systems that Don created and enable the schemes and problems that David has described in part, and also contribute to another huge problem, which is the general visa overstay problem in the country. And this is important at this time because of the problems that we've seen, things that we've learned recently from the less than adequate screening that took place of the San Bernardino terrorist immigration benefits application to what we learned yesterday about the fact that people who are participating in criminal trafficking organizations often are abusing our legal immigration system, to what we know about the overstay problem is that our processing and screening are not adequate now, and as a result, we understand that the House Judiciary Committee is considering legislation to implement some of the needed changes that have to be adopted in order to confront the very severe threat that we face now. So to be able to better prevent illegal immigration as well, which in itself is not only a security risk, but a fiscal and economic problem. So one of the two biggest problems for the agencies that process visas and immigration benefits is the sheer volume of applications that they are faced with processing. The workload is absolutely mind-boggling at these agencies. And in your packets, I included a couple of charts that illustrate the growth in the workload that has taken place under the Obama administration, just as a point of reference for time. The Obama administration has presided over and also deliberately contributed to a significant increase in the volume of visas that have been issued. If the Schumer-Rubio Gang of Eight bill had been adopted, and many people are still pushing for those very same changes to the law, this workload would have been at least doubled as well. It's enormous now. If the Schumer-Rubio bill had been adopted, it would be greater still. In 2014, the embassies and consulates of the State Department processed nearly 470,000 immigrant visas, which are these, each year, or that year, and more than 11 million temporary visas. This was an increase of more than 1/3 just since 2008. The immigrant visa workload has remained flat, as you can see by the bars, even though immigration has been gradually increasing. And that's because more and more of the green cards that are being granted right here in the United States to people who are already living here. All of the increase in the State Department's workload has been in the processing of non-immigrant visas. And this has happened even though the visa waiver program has been growing significantly as well, with more countries being added to it. So, one of the big arguments for the visa waiver program, which allows travelers to enter without having applied for a visa and being screened by the consular department, is that it reduces the workload for the State Department. But somehow the State Department is issuing more and more visas, even though more and more people are also entering through the visa waiver program. And you can see the impact in the border crossing volume stats, which is the lower table there. Visa waiver program entries have gone up by about 5 million a year since 2008. And air and sea entries have also gone up significantly, as have border crossing card issuances, which are basically temporary visas that are issued to Mexican citizens that are supposed to be for people to stay within the border area to visit family and friends or to do shopping or conduct business. Those have gone up enormously under the Obama administration. As Don said, the USCIS workload annually is 6.5 to 7 million applications each year. And again, all of this would have been exacerbated had the Gang of Eight bill been adopted, but it's been going up even without that due to policies of the Obama administration. Now, I don't know the most current consular staffing levels, but in 2012, there were about 1,700 consular officers stationed overseas to process these less than 500,000 immigrant visas and more than 11 million non-immigrant visas. So if all of them were working on NIVs, which they aren't, a lot of them are working on immigrant visas and American citizen services, but if all of them were working on the 11 million non-immigrant visas, that's about 6,600 non-immigrant visas issued by every consular officer overseas in a year. Now, the staffing levels of the consular sections have increased pretty significantly since 2002, from about 1,100 in that year to about 1,700 today. So that's about 35%, and that's about how much the NIV workload has grown as well. But when you consider that after 9/11, it was general, even before 9/11, but especially after 9/11, when we understood that the worst case scenario of making a mistake in issuing someone a visa could be that they would be a terrorist who would attack and kill thousands of Americans, everyone acknowledged that the State Department did not have enough people to adequately process these applications. But even today in 2015, now we see that pretty much the staffing has grown proportionately to the workload, which means essentially we're in the same position now as we were around 9/11, with inadequate staffing in our consulates overseas to manage the crushing workload that they're trying to deal with. Now, to be fair, there have been some very significant technological advancements, but the staffing levels have not changed. And that's why it was easy for me to see, but surprised a lot of people, how little attention was given, for example, to the visa application for Tafshin Malik, one of the San Bernardino bombers who came here on a K-1 fiancé visa. That, you know, and judging by the documents that have been released since that attack, we can see that very little time and attention was given to her application, despite where she was, the part of the world that she was coming from, the fact that she was being given permission to live in the United States permanently and become a citizen beyond the path to citizenship. Very little time was spent processing that application. And we know that, for one thing, she made misstatements on her application. No one ever checked to try to verify any of her claims. And there are also some indications that, you know, perhaps the consular officer didn't really ascertain that she and her fiancé were even in Saudi Arabia at the same time to become engaged. But clearly, we simply do not have the human resources needed to adequately vet the applications that people are coming in. This is, again, another kind of worst-case scenario example. The other major problem that has not changed significantly since 9/11 that I think is as big a challenge as the crushing volume of applications that officers need to adjudicate is the emphasis by the agency leadership at the State Department, but also at USCIS, on the facilitating the travel of people to the United States and servicing the people who are applying for these benefits and processing these applications as quickly as possible. So the emphasis still really is on the quantity of applications rather than the quality of the adjudication. Now more than ever, it's apparent that applicants need meet no more than the paper criteria for the visa or benefit. In other words, there's little to no scrutiny that takes place or assessment of the credibility of the applicant. And that's the kind of assessment that can only be done with human interaction. In other words, it's easy to run people through databases to see if they show up on, on the list of known terrorists or as someone who has a criminal record. What you can't check a database for is, does the applicant seem credible? Like, is a person who's more qualified to study horseshoeing trying to get into a selective institution like Harvard University or some other school? Does their story make sense? Are they credible? Does this look like an appropriate relationship? There are all kinds of questions that a trained consular officer can ask that if thoroughly investigated would lead to the proper denial of more applications and possibly could have prevented the approval of someone like Tashfeen Malik and other terrorists who've managed to infiltrate our system. I mean, we know now from documents that have been released by the Senate Judiciary Committee that more than 100 people associated with radical Islamic terrorist groups have been able to come in through our legal immigration system or are the children of people who've come in through our legal immigration system. So clearly mistakes are being made. And the other evidence that mistakes are being made on a very grand scale is the number of overstays that we find in the country. So, and this is a problem of leadership, not a question of technology. The law does not require that all applicants be approved if they meet the paper requirements for the visa. For example, if a student says, I've been accepted at X institution, that shouldn't be enough to just issue the visa. On the contrary, there are many grounds for denying visas that are rarely invoked nowadays, whether it's someone's suitability for an academic program, whether it's an accredited academic program, whether the person has ties to terrorism that might be detected, or even has the ability to be economically self-sufficient. So the results of this failure to uphold any standards means, of course, that we're failing to detect terrorists, people who are being trafficked, people who commit fraud, and ordinary overstays. The number of visa overstays is a large share of the illegal alien population. The generally accepted estimate for the size of the population is about 4.5 to 5 million people in the United States today who entered with a visa and overstayed. That's about 40% of the illegal population. For years now, DHS has been collecting biographic arrival and departure data for visitors who come in by air and sea. This information would be a hugely valuable tool for the State Department to use to evaluate, to understand if they are making the right decisions in general for visas, to understand who's not leaving when their visa or their authorized duration of stay expires. What countries are the overstays coming? What categories are bringing us a lot of overstays? But the Department of Homeland Security has yet to disclose anything that it has found from analyzing these arrival and departure records. But one of the very constructive provisions that was in the omnibus budget bill that just passed Congress and that the President signed about a month ago was a provision to actually, Congress has been demanding this data for many years. DHS has never given it to them, even though they have it. Now, because of a provision in the budget bill that just passed, Congress threatened to withhold certain funding for DHS until they submitted this long-awaited overstay report to Congress. And the due date for that report is actually a week from today. So if DHS does submit this report to Congress, we may soon have the opportunity to know what the State Department has been dying to know and other analysts have been dying to know is who's overstaying from what countries and what categories of visas. Critical information. From what I've seen of official data and academic reports on this subject, we can expect that this overstay report, if DHS releases it, will confirm that overstays are definitely contributing to the illegal immigrant population in a significant way, probably about 250 to 300,000 new illegal arrivals a year on overstays. The report should also confirm that the visa waiver program is contributing more than its share of visa overstays, and that certain countries, including a few that are associated with national security concerns, have alarmingly high overstay rates. So what should be done? There obviously there are improvements that need to be made both in the tools that adjudicators have to evaluate these applications, but also equally important, the policies that exist that they follow when they do their jobs. Clearly, we need to improve the staffing ratios of officers both at the State Department and USCIS, so officers have more time to review cases. We need to finish the entry-exit tracking program so that we have more complete data on both entry and exit that our agencies can use to find out where the problems are. The benefit fraud assessments that Don described are a hugely helpful tool to use. And there needs to be a comparable program, visa fraud assessments, at the State Department. This is a proven way to deter and detect fraud, and it needs to be done by both USCIS and state. But obviously, we need to adjust certain policies as well to make improvements possible. There is now too much staff time that is spent on the wrong kinds of applications. So the first thing that I would recommend in terms of specifics, and I've got 4 that I want to quickly go through, that I hope will be that the judiciary committees will look at when they're crafting legislation to respond to the visa screening problem. The first one is that to address this problem of too many staff working on the wrong applications is to just simply stop accepting petitions if a visa category, a green card or immigrant visa category, is not current. Right now, we have a huge waiting list of about 4 million people waiting for their immigrant visas or green cards. Some of those waits are 5 to 10 years long. There's no reason to actually accept and spend time processing those petitions to sponsor immigrants. It's a waste of the staff time at USCIS. State Department used to do this work. They don't anymore. In my opinion, this is a complete waste of time, and we shouldn't spend any time on it at all. Simply say that our government is not going to accept applications to sponsor an immigrant until there's a visa available within the next couple years. And that would free up an enormous amount of staff to process other types of applications that are more likely to be issued in the near future. It also removes a big incentive that people have to just file the petition to bring in an immigrant, knowing that it's not going to happen for a few years out, and relieves the pressure that that some advocacy groups have to simply issue people a work permit, even though they're not likely to get a green card anytime in the near future. But the main thing is to reduce this workload. Secondly, the San Bernardino terrorist case and also that OIG report that came out yesterday on the human trafficking organizations using our legal immigration programs demonstrates that the imperative to vet the sponsors as well as the applicants. That you should not, we should be taking a look at who is sponsoring people for immigration benefits. I believe that if USCIS had vetted Saeed Farouk, Tashin Malik's husband, as thoroughly as they would have vetted an alien, they might have been able to learn of derogatory information of concern that might have flagged that application for further investigation. This has to, and it's clear from the OIG report on the human traffickers that if there were more vetting of the sponsors, some of those human traffickers would have been detected. Right now, there's a lot of stovetyping of information. The Obama administration has adopted very strict confidentiality policies that apply to immigration benefits applications that the Gang of Eight would have codified in the law that prevent the benefits granting agency from sharing information with the enforcement agencies. And that's what caused the problem in these human trafficking cases, was that there was not proper information sharing. USCIS knows a lot about people who are applying, who are trying to bring in people. It should be of interest to immigration enforcement if smuggling organizations, traffickers, or people with ties to terror groups are trying to bring in people for green cards or any kind of immigration benefit. This has to include fingerprinting. And I did a blog for our website that shows the difference between fingerprint-based checks and biographic name checks and the kind of checks that are currently done on sponsors. But you simply shouldn't be able to sponsor someone for a visa or green card if you have a criminal record. That's serious. If you have involvement in any immigration fraud or crime, and if you're not financially self-sufficient. In other words, if you're using welfare programs or are dependent on affidavits of support from third parties to show that you can actually support the people that you're asking to bring in as immigrants, if you can't show financial self-sufficiency, you should not be allowed to sponsor someone for a visa. Clearly, there need to be more interviews mandated as well, especially for marriage cases. I think the petitioners and the applicants need to be interviewed together in their home country. I think that would assist the screening. DHS needs to pay more attention to who it's allowing to accept foreign students to address the student visa fraud that David talked about. And finally, what I would like to see are mandatory triggers for enhanced screening of visa applications based on empirical studies like the benefit fraud assessments that Don described and the visa fraud assessments that should be taking place. And also the overstay rates and the refusal rates, so that we know, again, which applicants are the problem. It's not enough to say, oh my gosh, we're letting in too many people, let's just reduce it across the board by 10%. That's not gonna really get at the fraud and security problems. What we need to do is study where the fraud exists, where the problem applications are, and actually not just do the studies, but require the government agencies that are processing the applications to implement enhanced screening measures for certain countries and certain types of applications so that a visa officer in Islamabad is not spending 20 minutes on a fiancé visa application and doesn't have time to check out the statements that are made on that visa application, that they have time to maybe look at the social media posts if appropriate, or check other parts of that application that can be verified, even with the help of local staff. It's not enough to study the problem. Corrective measures need to be implemented, and this has been proven, as Don described, that the fraud rates in certain categories, when enhanced screening is applied to the process, can be reduced dramatically from double-digit to single-digit fraud rates. Obviously, that also has to be supported by enforcement from our enforcement agencies, and that's not happening. But mainly what we need is, we know that we have the tools. What we're lacking is not only the policies to use them properly, but also the leadership to make sure that they are actually implemented to the best effect. So now I think what we'd like to do is open it up to questions from folks.